So anytime anybody ever tells you this is not a radical court, by definition, it is. But regardless, the Senate is supposed to act like a break and be like, no, you can't have cookies until you eat your dinner, right? That's the Senate. And it works really well on paper. The problem is when you have career politicians, you have lobbyists, you have influence, you have money, and all those other things, it becomes a problem. And of course it becomes a problem if the entire, both cameral bodies of the legislature are, kind of like on the same page. I mean, theoretically that should be fine, but because we're in an age of gerrymandering and no term limits and stuff like that, it can be a little not the way it's supposed to be, and you're seeing a lot of that. But yeah, so we have all these checks and balances based on the federal government, but then the 10th Amendment does this really cool thing where it just basically says, like, anything not afforded to the federal government relies on the states to decide. And that's where you hear a lot of arguments, especially from the right, and you've heard it for decades, right? States' rights, states' rights. The whole argument for overturning Roe v. Wade was that it wasn't a federal decision to be made. It's not like the Supreme Court came out and said abortion's illegal. That's not what they said. They simply overturned the ruling that said that it was a federal protection. And this Supreme Court, as radical as it is, and again, I'm defining radical by a court that would upend years, decades of stare decisis, which is basically precedent. Like, that is radical. That is the definition of a radical court. So anytime anybody ever tells you this is not a radical court, by definition, it is. And you can agree with them or not agree with them, but it is by definition a radical court because they overturned their own ruling, right?